judgment in the matter of Actavis Group and others versus ICOS Corporation and another.
Lord Hodge will explain the decision of the court.
This appeal is concerned with the law of patents. It concerns the test for an inventive step, which is one of the criteria which must be met before an alleged invention is entitled to the protection which a patent confers to enable the inventor to recoup the costs of his or her research and, hopefully, to profit from that work. Section 3 of the Patents Act 1977 treats an invention as involving an inventive step if the invention was not obvious to a person skilled in the art, having regard to the state of the art, which in this context refers to all relevant matter which has been made available to the public at the priority date of the invention. In this appeal, the court is concerned with the drug tadalafil, which is sold under the brand name Cialis for the treatment of erectile dysfunction, which I will speak of as ED. The patent in question, which I'll call the 181 patent, that's a shortened version of the patent number, is a dosage patent. What is said to be inventive is not that the drug is effective to treat ED. That discovery was made in an earlier patent, which is called the Dogan patent. Rather, the discovery claimed in this dosage patent is that the drug is effective in treating ED at a low dose with minimal side effects. As a result, the drug can be taken daily for chronic use rather than on demand. It thus avoids the need to foresee when sexual activity might occur and is said to be a significant technical advantage over a similar drug, sildenafil, marketed as Viagra, which is approved for on-demand use only. Manufacturers of generic drugs, which do not generally carry out the extensive and costly research of pharmaceutical research companies, but produce drugs the patents for which have expired or which are not entitled to patent protection, raised proceedings to challenge the validity of the 181 patent on numerous grounds. The only ground of challenge to the 181 patent which remains in issue in the appeal to this court is the question of the inventive step, also known as the question of obviousness. In the High Court, ICOS and the manufacturer of Cialis, Eli Lilly, were successful in their defense of the patent, as the judge concluded that the 181 patent involved an inventive step and that the dosage regime was entitled to patent protection. The generic manufacturers appealed to the Court of Appeal, who disagreed with the judge and held that the invention was obvious. The Court of Appeal therefore revoked the patent. ICOS and Eli Lilly appealed to this court. In unanimous judgment, this court dismisses that appeal. In the judgment, the court explains that there is a patent bargain by which the inventor obtains a monopoly for a limited period of time in return for making a technical contribution by disclosing the invention and making it available to the public after the patent has expired. The Dogan patent revealed that tadalafil had the potential to treat ED, but that patent did not identify the optimal dose for that treatment. On the hypothesis that the Dogan patent was valid, it must be treated as disclosing to the person skilled in the art that the drug was an effective treatment, and that person could, without any inventive skill, identify a suitable dosage regime for the drug to provide that treatment. Implementing the Dogan patent by discovering an effective dosage regime would not of itself involve an inventive step. The question, therefore, is whether the 181 patent, which was a dosage patent, involved such an inventive step. In the judgment, the court discusses the approaches which are often adopted by the courts in the United Kingdom, called the windsurfing Pozzoli approach, and by the European Patent Office, called the problem and solution approach. But the court stresses that no approach should be applied in a mechanistic way, and that the question of obviousness must be considered by evaluating the facts of each case. The court explains that pharmaceutical research proceeds through a well-established series of phases by which the safety and efficacy of the drug and ultimately the effective and often optimal dosage regime is ascertained. The court rejects the argument of the generic drug manufacturers that the obviousness test requires it to disregard any matter which was not available to the public when the skilled team began their research programme. It also rejects the suggestion by ICOS and Lilly that anything which is the product of well-established or routine, of a well-established or routine programme of research which was within the skilled team's repertoire cannot be inventive. Instead, it adopts the approach of both the trial judge and the Court of Appeal that the test of obviousness depends on the careful consideration and evaluation of a number of different factors which may differ from case to case. In the present appeal, the Court identifies 10 factors which are relevant considerations in the circumstances of this case. As the trial judge sought in his careful judgment to balance the relevant factors, a question arises whether the Court of Appeal, which accepted his findings of primary fact, could properly reverse his finding that the claimed invention was not obvious. The court explains that an appellate court can intervene in such circumstances only if the trial judge has committed what is sometimes called an error of principle. In this case, the judge, without relying on hindsight, found that the skilled team, having discovered a therapeutic plateau, in other words, that the drug remained equally effective when significantly lower doses were tested, would have been very likely to continue by testing yet lower doses and thus come upon the dosage regime, which is the subject matter of the patent. The Court of Appeal considered that the judge was wrong in principle not to appreciate the logical consequences of that finding, which, as I've said, did not depend upon hindsight, namely that the skilled team would test the lower doses and would find the subject matter of the patent, making the invention obvious. This court concludes that the Court of Appeal was entitled to interfere with the trial judge's assessment and carry out its own evaluation of the factors, which pointed towards and away from the conclusion that the invention was obvious. The court detects no error in the Court of Appeal's approach. It was therefore entitled to hold that the patent was invalid, as it lacked an inventive step.